MGNRGA are not being approved by the account officers, and those are being passed through
Where is the
the
proof of this representation?
Malad. Malad is this representation is before the opposite party number one. Malad is the
No,
chief
no, where is the
secretary.
proof of dispatch?
Malad is through postal Malad. The postal slip is not there, Malad.
You want to make a fresh representation? Yeah.
So a date may be given, Malad. I have to give in the postal.
No. Counsel the petitioner seeks leave to withdraw the present petition, liberty to file a fresh representation, and after following it on it,
All this representation may be considered, Malad.
to seek appropriate representation. Unless you submit proof, you don't do that.
Two.
Police.
May I please your lordships? My lord,
Yes.
the petitioners have challenged the proposal given by the district excise officer Koraput to open up a IMFL on sub, my lord, in the scheduled area, my lord. Scheduled plot, my lord. Plot
So there's
number.
already an opportunity to file objections.
My lord, we have filed it under annexure 3, my lord.
Let's see that.
Before
Ready
the
to
OP
file.
number 2, my lord.
Okay, then what happened?
And nothing, no action has been taken, my lord. Well, at least the OP number 2, collector and district master Koraput may be directed to
Whether that is pending before them or it has
pending.
already.
Still, I have taken specific pleading that is still pending and no action has been taken on.
No. This Hello Brothers is what?
Hello Brothers is the name and style of the proposed, my lord, shop.
That is the name of the shop.
Name of
Your
the shop.
Lordship may see page 14,
No.
annexure 2.
It's represented by a proprietor and all that. He has already been awarded the shop.
No, shop is there. The applicant is in the name of the shop, the application is usually made. So he has made. That is not the.
No, he has only made an application, not
Yes,
yet
yes, that
granted.
is under. Annexure 2 may kindly be the Form 8 notice. The last date of is 16th March 2023. Your Lordship can verify my.
Right.
In ODI it is written. And the so-called objection, your Lordship may kindly see at page 16, that is 23rd March 2023. So
13 March. 13, 13. 13/3/2023, my lord.
23, it must have been again 13.
My lord, therefore, no order has been passed on our objection, my lord.
You want to find out?
Yes.
Or it is stated that despite objections having been filed to the proposal, to the application made by opposite party number 4 for grant of an IMFL off shop, is it?
On shop, my lord.
On shop,
On
sorry.
These are all
License, on shop license. Those objections are yet to be dealt with by the authorities. Paragraph Mr. D.K. Manthilan at AGA states that he will seek instructions. List on 28th June.
My lord, I pray no final decision may be taken, my lord, without the leave of the honorable court.
If it is taken, you will challenge it, sir. That's all.
Item number 3. May I please your lordship?
My lord, extra copy, my lord, I will give for.
Yeah, give it to him.
May I please your lordship? I have filed a memo for withdrawal of the writ of appeals.
Okay. Memo taken on record. Disposed of is not pressed in light of the memo.
Grateful lordship. Item number 4.
May I beg to state my lord, on behalf of SK Naik, the matter may be kindly taken up tomorrow since he is under influenza, attack of influenza and undergone for COVID test.
Acha, counsel for the petitioner stated the appellant stated the unwell. Let's go on. June. Sorry, 23rd June. 23rd June.
Item number 5.
May I please your lordship? The appellant challenges order of honorable single judge at page.
So if there are similar matters, tell
Similar
us.
matter, your lordship. Posted to 27th September 2023, my lord.
Or
I am
same one. Right. Same one.
obliged to.
Item number 6.
The facts of the case is like this, my lord. the respondent filed a civil proceeding in the family court Jaipur at Rajasthan for dissolution of the marriage. The appellant, my lord, thereafter filed a transfer application before the Honorable Supreme Court, and Honorable Supreme Court directed the matter to be transferred to the family court at Jharsuguda. And while directing so, the Honorable Supreme Court also held that the conciliation proceeding could be held through the virtual mode or either by the parties or through their counsel. And the further direction was made the family court to endeavor to dispose of the case within a period of 6 months. Thereafter, my lord, the case was posted on 3 occasions for conciliation. My lord. On the first date, the respondent appeared virtually. The appellant filed an application ill-advisedly for physical presence of the respondent. So that was rejected, and the case was posted on 23/11, next date, 23/11/22. On which date there was a lawyer strike, and the appellant was not given a Zoom link, for which the appellant could not appear even in a virtual mode. Thereafter, the next date was posted close on the heels of the 23/11 on 2/12. And that was the date because the appellant counsel could have obtained the date within a short time and intimate her. And respondent also admittedly did not appear, my lord, on the third date. Neither he nor his counsel, my lord. Then thereafter, the court closed the case for conciliation, apparently, and fixed the case for filing of written statement. Written statement was filed, the issues have been settled, and thereafter the appellant filed an application to give her another chance for conciliation, my lord. That was rejected. Annex 3 application in the writ application, that was rejected. And the court said, the learned family court said, there is no urgency for that. And if it is possible, it can be done during the trial, my lord. That was challenged before the Honorable High Court, my lord. Honorable High Court, while issuing noting the Rule 18 of the Family Court rules, which requires if the parties are not present, then the procedure to be followed by the counsellor has not been complied with, they issued notice for a short returnable date and fixed and granted interim proceeding, stay of proceeding. The learned family judge thereafter wrote a letter to the Honorable High Court saying that the matter with regard to 6 months timeline has been suppressed and this order was obtained. Based upon that, on 19/4, the Honorable Single Judge vacated the stay. Thereafter, the case at the instance of the respondent was adjourned to 5th of May. On 5th of May, the Honorable High Court said that no error has been committed in not granting any further chance for conciliation and awarded a cost of 25,000 of the appellant, who is a postgraduate student, my lord. And our 24 application has not yet been disposed of, still pending consideration, on the ground that suppression of material fact. This is not an apparent suspension, my lord. A lordship made on a similar footing where a company filed a suit as well as the writ application on the very next date. And the Honorable Supreme Court and suppressed the fact with regard to the suit, my lord.
Why are you making such a big issue of this? You went to the family court saying we want a chance at reconciliation.
Conciliation.
That application was rejected.
Yes, ma'am.
That order has been affirmed by the single judge.
Yes, ma'am.
So why are you agitating this again and again?
With the reason being, my lord, I want to go back to my husband, madam.
So you can't compel anybody, sir. The whole idea of conciliation, mediation is both parties should agree.
Yes.
If one party is refusing to come to the table, it will be a pointless exercise. It will be a non-starter.
Yes, madam. That's right. That could be that.
In all mediation exercises, one of the first things they tell you is parties must agree to mediate. You can't compel parties to mediate.
Right. I can't compel. But
you can't compel parties to reconcile.
But that should be.
Which is why Section 9, even if you get an order in your favor for restitution of conjugal rights, if it is not implemented,
yes,
you cannot compel parties.
Yes, ma'am. Then, my lord, that should be what is the report, man, that will influence the court, my lord.
What influence? What?
The report of the attitude of the parties, my lord.
No, that is the fact is that you have this attitude.
Rule 18
don't turn up for conciliation.
Rule 18, my lord, clearly provides the procedure to be followed.
The problem is why you invited this causes with suppression of facts.
That's right, but this is not
clean. You did not come clean before the court on all that has happened.
All that matter, my lord, it's not a suppression, my lord. I place my lord, this 2004 Supreme Court, your lordship may kindly say that paragraph 12, my lord.
Sir, how can judgments substitute facts, you tell me? Some judgment of 2004, can it substitute the fact of your suppressing facts here?
Well,
how can a judgment substitute facts?
No, facts. In that case, my lord, the parallel proceeding suit was suppressed in the High Court, my lord, in a writ proceeding. There are no whisper. Here it has been made. In the paragraph 4, I have stated that the Supreme Court order is there And also the trial court also in the rejection order, they never referred to that 6-month period also.
So you never
Though in the earlier conciliation proceeding,
produced before the single judge, the Supreme Court order. The family court judge had to send the High Court, the Supreme Court's order. And then your opposite party had to bring to the notice of the single judge that this is a Supreme Court order.
no, opposite party never filed an application for vacation of stay, my lord.
Sir, don't see, the point is, the fact is you did not bring it to the, you were before the court.
Yes, my lord.
It was on you to place the full facts. You did not place the full facts.
Ma'am,
That's a
what I
long and short of it.
What I have stated, my lord, may I just read it, what I have stated?
And
That the petitioner respects to submit thereafter on a transfer petition filed by the
Is this writ
petitioner.
appeal maintainable?
So,
Is this writ appeal maintainable?
yes, because the direction to pay 25,000 cost, it is not within the 227, my lord.
Why?
And that,
Why is that not within 227?
my your lordship may see that that's another decision, my lord, of this honorable court. Para 9, my lord. No, little differently worded, my lord. Para 9 and 10 at page 4. Because it is
Take note of the full bench, sir. This is the whole problem.
here this is the, my lord, this
There
is
is
the
a
case.
full bench judgment of this court in Dr. Mahmood Saud. That's a full bench judgment which is not noticed here.
The 226 and 227 application, both, my lord, here. Where the fact, because it is not CMP, my lord. Para 9, my lord. Where the fact justified a party in filing an application either under Article 226 or 227 of the Constitution, and the party chooses to file his application under both these articles, in fairness and justice to such a party, in order not to deprive him of a valuable right of appeal, the court ought to treat the application as being made under Article 226. And if in deciding the matter, the final order, the court gives ancillary direction which may pertain to Article 227, this ought not to be held to deprive party of the right of appeal.
Again,
under
comes to
clause
this, the last sentence, the vital factor for determination is the nature of jurisdiction.
nature and character of the order passed by learned single
What
and
is
the
the nature
type
of
of
this
direction issued, my
What
lord.
is the nature of this jurisdiction? When you file an against a family court order, what is the nature of the jurisdiction?
My lord? Sorry, my lord, I couldn't.
Just come to the last sentence of this very para you're reading.
Para 10, my lord.
Para 9, last sentence.
Yeah, the vital factor of the determination of maintainability of intra-court appeal is the nature of jurisdiction involved by the party and the true nature of the principal order passed by the learned single judge.
So the question I'm
nature of-
asking you is, when you are challenging an order of a family court, what is the nature of jurisdiction which the single judge is exercising?
226 certiorari also, 226. Your lordship.
See, because it suits you, you say 226. Tomorrow, if you're on the other side, same thing, you'll say 227.
Well,
You must be an officer of the court. Just because somehow you want to get this writ appeal admitted, don't simply say it's 226. When you're challenging an order of a family court, interlocutory order of a family court in the High Court, which jurisdiction do you exercise, sir?
If a civil suit order is passed, or order passed in a civil suit is filed, High Court do not entertain a writ jurisdiction, but only under 227. But where an order is passed by the family court, High Court did not allow a CMP application to be filed, but a writ application is to be filed.
What will that jurisdiction be, sir? There are two kinds of jurisdiction, 226, 227. Against an interlocutory order of a family court, what is the jurisdiction that the single judge is exercising? Don't simply say 226 because somehow you want this writ appeal to be admitted. What is the nature of that jurisdiction?
If interlocutory application, my lord, it's both under 226 and 227, my lord.
This is not,
And my
you're not
lord,
clear, sir. You're not clear.
and your lordship may
Better study the point and address.
suppression of
Serious
matter.
matter. If you're seriously wanting to pursue, you have to be of assistance to the court. Don't, off the cuff, don't simply say because somehow you have to get over this problem. Supported by case law, there are 25 high courts in this country. Is there in some other high court? I'm sure this problem was faced.
No, my lord, with regard to the suppression, my lord, just 2 lines, my lord.
First, you show satisfy and maintainability. We're just multiplying litigation over some small issue of reconciliation. You just want to multiply.
The family has to be conserved, my lord.
See,
There cannot be,
both of you,
it cannot
both
be-
of you have tremendous litigating capacity. That much is clear.
It is.
You have no problems at all. Go on fighting over the smallest issue. Keep on filing applications.
When Rule 18, my lord, provides if either
You
of the
satisfy us on maintainability. You say, counsel for the petitioner, appellant seeks time to satisfy the court on the maintainability of the present appeal, which arises from the dismissal by the learned single judge of a writ petition filed by the appellant against an interlocutory order of the family court. Where is this? Family court, Jharsuguda. Full stop. At his request, list on August 14th.
Yeah, Lordship may put soon after the reopening, my lord, 20th June, because the next case date is 22nd June, my lord.
What will happen on 22nd June?
The hearing has been fixed for hearing.
So what? That has nothing to do with this, sir. That's the main matter to be heard by the judge.
But I'll prepare during the vacation. Your Lordship may call it on soon after the vacation.
It's all right, sir. There's no hurry at all.
20th June, my lord.
No, nothing. There's absolutely no hurry. Yes.
Your Lordship may fix it end of June first.
Meanwhile, you please convince the two parties to reconcile. That will be the best news for the court. Instead of going on fighting.
With regard to the suppression of the fact and
all this will, you tell the court next time, sir, we have settled all our disputes. All this will be set aside. That's the best. Every court wants to hear that only. In matrimonial cases, the judge is the happiest when he is told parties have settled their differences. All right.
Your Lordship, we fixed it last week of June.
It's all right.
June, my lord. My humble prayer, my lord, last week of June.
All right. 23rd June. All right.
Oh,
23rd. All right.
Item number 7. Item 7.
None appears dismissed.
Item number 8.
My lord, maybe not pressed. CMFL maybe not pressed in view of the less limit, tax limit of the
Dismissed is not pressed.
9.
Same.
9, 10, same, my lord.
All right. All the same.
My lord, 11 is on behalf of Mr. Satpathy, my lord, that his name is mentioned. That is the not pressed.
Not pressed. Dismissed is not pressed. All right.
Item number 12.
Well, my lord, I have to file a supplementary affidavit. May I pray, my lords, a direction be issued to the Executive Engineer Division 2, CMC, to file that affidavit. Lords, I'm so sorry. I'm more in the habit of playing football.
At the request of Mr. Debashish Naik, a specific direction is issued to the Executive Engineer Division 2, CMC, to file the affidavit in question. In terms of the order dated 7th February 2023. The affidavit positively be filed on or before 21st June.
Your Lordship, petitioner is appearing through virtual mode.
All right. List on 23rd June. 23rd June, sir. My lords.
Item number 13.
Your Lordship, in this PIL, I am praying for framing of guideline for sale of noristherogen medicines with noristherogen composition, because the medicine is cancerous in nature, Your Lordship, and it is very harmful, and it has been sold without any proper guidelines and proper regulation, Your Lordship. Representation also annexure 2, Your Lordship.
Where is the proof,
Proof of representation? Page number 35, Your Lordship.
All right. The petitioner's representation bracket annexure 2 will be examined by the Director General of Health, Public Health, Director of Public Health, Bhubaneswar, bracket opposite party number 4. And after giving the petitioner hearing, a reasoned order shall be passed not later than 14th August 2023 and be communicated to the party to the petitioner within a week thereafter. The court clarifies it as not expressed.
Item 14.
My lord, item 14, I am challenging annexure 8, by which the license of IMFL's ONSOP has been renewed, rehearsing the provisions of the Orissa Excise Act as well as the PESA Act.
You know, all these off-shop, on-shop, hereafter we should insist that the petitioners who profess to be public interest litigants are actually doing it out of their own costs. You get a feeling that you're all set up If
No,
a
my
rival
lord.
has lost his ability to stop his man from setting up a non-shop off shop, PIL is another route.
No, my lord, this is not a PIL. Your lordship may
It's not a PIL.
If not a PL, then it is.
Then it has to
will
go.
to.
My lord, it was listed before Honorable Justice Sarangi, but he sent it back to your lordship. That
No. How is it? You are asking a relief for yourself?
Yes.
Oh.
My lord, it is, my lord, admittedly, it is a scheduled area. As per Section 27 of the Orissa Excise Act, without the permission of the Grama Sabha, no license can be renewed. And apart from it, my lord, under the PESA Act also, there is a provision under Section 4M. Your lordship may kindly see 4M.
All right. You just say, okay. You say the three petitioners have filed in their capacity as sarpanches and members of the Kelapada Gram Panchayat. And the specific prayer is that the IMFL Oshop should not have been permitted without prior consultation with the Gram Panchayat. Full stop. It's a relief being specifically sought for the petitioners themselves as belonging to the scheduled tribe community, bracket ST, bracket. This is more in the nature of a single court's class action litigation and not as a public interest litigation. Stop. In fact, your earlier writ petition was there. At
Yes,
page 22.
earlier writ petition was
In fact,
there.
an earlier writ petition by these very petitioners was entertained by the division bench, which passed an order on 14th March 2023. Bracket annexure 6 to the writ petition. Bracket. Paragraph. Consequently, the present petition be listed before the same bench.
My lord, may I pray one prayer? Day after tomorrow, let it be listed.
All right. Day after tomorrow, whatever, Thursday.
Obliged.
All right.
Item 15.
May it please your lordship. When the petitioner number 1 is a registered society entrusted with the distribution of rural piped water under rural piped water schemes of the state government, my lord. My lord, since 2013, they have been discharging this duty of supplying drinking water to the 500 households of Gurujang area in Angul district, my lord. In the recently, the opposite part number 4 is creating disturbances in the administration of the work of the society, my lord. Regarding that, we have made a grievance before the collector, my lord. That grievance that they are not paying, this committee has to work as a part of the panchayat, my lord. And the sarpanch is not paying the electricity bill for that reason. All
right, the petitioner's representations bracket annexure 3 will be examined by the
OP number 2.
Collector Anugul.
Collector Anugul, and after notice the petitioners
And opposite
party number 4. And after giving them a hearing, a reasoned order shall be passed not later than 14th August and be communicated to the parties within a week thereafter. The court clarifies it is not expressed in the
Item number 16.
May please, lordship. And here the petitioner filed this application for direction to the opposite parties for eviction of unauthorized occupants, my lord. The representation is pending under annexure 2 series, my lord. Page number 16, my lord.
Where's the proof?
My lord, here they have received, my lord.
Where?
On page number 16, my lord. The collector has received on...
There's no stamp, nothing. This is how collector receives applications, is it?
And also the sub-collector, my lord, have received.
11th April.
Yes, my lord. 11/4/2023, my lord.
You don't even wait for a month, sir. 9th May, you filed it promptly. Is this how the receipt is
I don't know, because who has signed it also, that is not A. Palla.
And also the sub-collector, my lord, have received.
How do we know his signature?
Let him make a fresh representation before the Tahsildar, because Tahsildar is to initiate the proceeding.
Constable petitioner seeks leave to withdraw the present petition with liberty to file a fresh representation before the Tahsildar. This time get a proper acknowledgement, sir.
Yes, my lord.
There should be a stamp, that diary number and all that. And
Yes,
after following up on such a representation, to seek appropriate advice in accordance with law. Disposed of his withdrawn with liberty is paid for.
Obliged, my lord.
Item 17.
My lord. The petitioners are villagers of the coffee culture and their land was acquired. And for that reason, we have, or earlier we have filed a petition before your.
When was it acquired, sir?
My lord?
When it was acquired?
It was acquired prior to, my lord.
No dates, nothing.
Nothing. The notification is also not.
Notification, that was not there. But in the Grama Sabha and Police Sabha, that was not the question. Because land was acquired and on Police Sabha and Grama Sabha, the RR colony was given for resettlement RR policy. And kindly have a glance to Annexure 4, the land allotted for RR colony, that was created by OB dump, overburden dump, my lord, by the NTPC. For that reason, we have earlier filed a petition for clear colony. Annexure 4 is the Tahsildar report that it is not fit for homestead because of OB dump. And for that reason, we have filed earlier. We have approached your lordship.
Right.
Kindly have a glance.
All right. Notice, Mr. Mohanty accepts notice for opposite parties 1, 2, and 3. And then 6, 7. Notice to the remaining respondents. Why pollution control board now?
Police, my lord, demolished our house in the area. And
notice to the remaining by Dasti. Returnable on the next date. List on. The replies be filed within 4 weeks of service of notice, rejoined for the next date. List on 11 September.
Item 18.
And interim application, my lord. Interim protection may be given. Not to create a OBDOM.
Notice on that also.
My lord.
Notice.
My lord, interim protection, if you will not given, matter, they will create OBDOM over the area.
Right.
My lord, till.
Item 18.
May I please, madam?
My lord, by special messenger, we will send, my lord, short date may be fixed for interim order.
You have to file replies. Can't hurry up. Yes.
18.
Short date may be fixed, my lord.
Not possible, sir. They have to file replies. It all takes time.
My lord,
you have to serve them. They have to file replies.
My lord, kindly have a glance to they have taken a decision. But kindly have a glance to page 57. My lord, kindly have a glance. They have taken a decision, but they have not implemented.
All right. Yes.
My lord.
Item 18.
May I please, my lord? My lord, the present petition is there from the village of Mangal Jodi, one of the well-known place of Khordha district, my lord. Since last few years, my lord, there is a new Gram Panchayat has been set up in that village, my lord. And that Gram Panchayat office was running in a temporary building.
The petitioner's representation, petitioner 2, will be examined with the Tahsildar Tangi. And after notice to the petitioners and giving them a hearing, a reasoned order shall be passed not later than 14th August and be communicated to the petitioners within a week thereafter. The court clarifies it is not expressed.
But until then, this will not go for.
It will be open to the petitioners to seek appropriate interim orders during the hearing. All right.
Item 19.
My 19 notice has been issued. Someone has appeared, his name first does not appear. Lordship can find it that he has also filed an objection to that effect.
What is the matter about?
The matter regarding the payment of dues, that is an employee of Bhaskar Textile. Lordship can find it from the page 33 impugn order before the Honorable Single Judge.
Have you been served? Who has filed this objection?
Mr. Pavitra Kumar Naik.
And Mr. Pavitra Kumar Naik, advocate, had filed an objection on behalf of the respondent. He is however not present today. The registry will telephonically inform him to remain present at the next date. Fifth, yeah, his name is shown in the cause list, sorry. 5th September. Sorry, 11th September, 11th September.
Item number 20.
Item number 20 was issued notice, and we also served copy on the council was appearing before the honorable single judge. Already served on 26th, on 16/3/2023. In compliance to my lord's direction.
Not delivered, sir. Fresh notice returnable.
And copy has been served.
Item 20, I have instruction to appear
We have
for the
served
respondent,
copy.
my lord.
All right, very good. So he's put down his appearance for the respondent. You need paperwork or you got it?
My lord,
We have served, already served.
I see.
copy by. But today we'll file the Uklat now, my lord.
All right. And says that Vakalatnama will be filed during the course of the day.
This is also rehabilitation matter. You also can fix it to 30th August, my lord.
All right. List on 30th August. All right.
Item number 21. May I please, lordship.
Order dated 21/6/2022 passed to the Honorable Single Judge, wherein the Single Judge has dismissed the writ petition, holding that the order impugned before the Single Judge was just a mere internal communication between the two offices, my lord. Lordship, the fact is that, my lord, the ancestor of the present appellant purchased the land, and during major settlement, they were outside the land for which the present appellant, who is a minor, and the property was under the superintendence of the Court of Wards, under section 10 of the Court of Wards Act, my lord. Thereafter, my lord, the present appellant filed an application before the sub-collector from Court of Wards, Sonpur, for release from superintendence. The sub-collector delegated the matter to the Tahsildar. My lord, lordship, a glance, page 38. Page 38, that kindly look into the matter and inquire into the matter. My lord, thereafter, my lord, the Tahsildar, without communicating the matter, page 40, my lord, intimated to the collector Suvarnapur. My submission is that whenever a property has been attachment under the superintendence of Court of Wards, my lord, when the minor ceased to be minor, it is automatically to be released by the Board of Revenue. That is, my lord, I have relevant provision of the Court of Wards, section 58, my lord. That is, my lord.
What is this defect?
Page 61. I have annexed the Court of Wards, my lord. Page 61.
Defect have to be removed, sir.
My lord?
Defect has been pointed out. You have to remove the defect.
My lord, the legible copy, that is, I'm not relying on that, my lord, that pages.
Then you will have to say that. You tell the registry that, sir. Defect has still not been cured. Last chance list on. July 25th. Defects be cured in the meanwhile.
Item 22.
In item 22, as per the direction of this Honorable Court, we have deposited 10 lakhs 10,000, and we have also filed the translated copy of the depositions, which of all the witnesses, and that entire amount has been deposited in the registry. That yesterday I have filed the affidavit, hard copy I have filed. That is the acknowledgement receipt is at page 18.
Or in compliance with the direction issued on 6th April 2023. The sum of 10 lakhs stands deposited.
10 lakhs 10,000.
10,000 stands deposited. Full stop. The said of the said sum, rupees 10 lakhs should be placed in the fixed deposit. Has it been placed?
It's placed.
And it has, the sum of 10 lakhs has already been placed in the fixed deposit. Additional documents have also been filed. Notice returnable. 12 September. 11 September.
Stay.
The sum of rupees 10,000 deposited with the registry by the appellant shall be released to the respondent number 1 when he enters appearance. By the registry to respondent number 1 when he enters appearance upon proper identification. There shall be stay of the impugned order of the learned single judge till the next date.
Item number 23.
Visual Lordship. 28(3), notice was issued. The state is the opposite by 2
You have not filed Vakalatnama, sir.
Vakalatnama initially I was appearing in the writ petition.
Here it is writ appeal, you have to file.
I will undertake.
Vakalatnama is so basic.
But that is
you see, despite respondents 2, 3, and 4 having been served, none is appearing on their behalf. Paragraph. Counsel for the appellant undertakes to file Vakalatnama before the next date. List on 11 September. All right.
Item 24.
In 16(3), my lords, notice was issued, but it did not back, my lords, from respondent number 3, my lords. It did not.
While respondents 1 and 2 have entered appearance.
Yes.
The AD notice, undelivered notice is not returned from respondent number 3. Fresh notice returnable 11 September. All right. Defect be cured in the meanwhile.
25.
May I please, Your Lordship? Your Lordship, on the last occasion, Your Lordship had directed the appellant to trace out the number of the contempt petition pending before, which was pending before the Odisha Administrative Tribunal. Your Lordship, on approaching the registry of this Odisha High Court, it could not be traced, and we have been directed to check from the Administrative Tribunal about the status of the contempt petition. They suspect that it might have been disposed of, and the Administrative Tribunal has sought for time to check, verify the status.
At the request of counsel the appellant, who needs more time to check the status of the contempt petitions. List on 11 September.
Obliged, Your Lordship.
Item number 26.
There are 2 speaks, my lord. I pray for 1 week's time to remove.
All right. See list on 11 September. If it's secured in the meanwhile.
Item 27.
May I please, Your Lordship? My lords, in this case, in the last occasion, Your Lordship directed to serve copies, and the same has been duly served on OP number 2, 3, and 4, my lords.
2, 3, 2. 1. Only 1.
No, 2, 3, and 4 also.
All right.
My lords.
What is the defect 6A? Yes.
My lords. Lords, what has happened in this case, after the completion of the entire admission process, my lords, 6 seats remained vacant in the Madhusudan Law University, Your Lordship. Out of that 6 seats, my lords, 1 was only SC and the rest 5 were of general category, my lords. Thereafter, OP number 4 along with another, OP number 4 belongs to SC category, and another petitioner in writ petition 34262 belong to general category. We have no grievance regarding that petitioner because that admission is done rightfully, my lords. Thereafter, my lords, OP number 4 approached this honorable court in WPC 34262, and the honorable single judge was pleased to pass an order on dated 9th of January 2023, my lords, and by virtue of this order, my lords, the the university by Annexure 11 admitted 2 persons into the LLM course, my lords. This is my only grievance. My lords, kindly have a glance to page number.
So when did the academic
27,
year
my lords.
begin? When did the academic year begin for LLM?
My lords,
this is 2022, right?
My lord, 2022. For
so
the
1
rest,
year is already coming to an end.
no, my lords, no. My lords, it's a 2 years course.
1 year is coming to an end, sir.
No, no, my lords. I'm clarifying that point, my lords. The admission, this two petitioners' admission was done on 24th of January 2023. It's only 2-3 months in meantime. And my lords, it's a general process, my lords. And my lords, we have, my lords, LLM course, my lords, time, it does not happen in everything in time, my lords. In this case, the admission process came to an end on 24th of January 2023. Annexure 11, page number 36, my lords. This is a letter issued by the university itself. My lords, kindly have a glance to page number 27, the merit list that was issued. My lords, my name is at rank 59.
Were you party to the writ petition?
No, my lords. It was the duty of the, my lords, the petitioner to make me party, or else even if the order was passed, then it was the duty of the university to intimate the persons who are above this petitioner to call them to take admission.
All right. The grievance of the appellant is that despite he being higher in the order of merit than respondent before, he was not made a party to the writ petition, which has been allowed by the impugned order of the learned single judge, directing the university to give admission in the LLM course to respondent before. Notice returnable. Sorry, respondent before has also been served, right?
Yes, my lords. It is the noting also.
It's very strange. Steps for limitation is not taken yet.
No, my lords. Actually, limitation by my lords, the registry is counted from the date of order. But my lords, I can only come to know from this 24th of January only, when the admission, these two persons took admission in the course.
All right. You see, a copy of this order be sent to the registrar of the Madhusudan Law University, requiring him to remain present on the next date to assist the court with the original records.
Well, it's university, Madhusudan Law University.
That's what, yes, Madhusudan Law University. The order be communicated to the registrar, that is opposite by respondent 2, forthwith by the registry. List on 23rd June, sir. 23rd June. All right.
Item note 28.
It will be more late, my lords. It will be more late, my lords. Right now, 3-4 months.
What can we do? You want to have before the vacation bench? Do you think something will happen in the vacation bench? All right.
Item 28.
May I please, your lordship, my lord. Here, my lord, I am challenging the order passed by Honorable Single Judge, my lord, in where I have filed a writ application. Sorry, I filed a writ application challenging the order passed by the Permanent Continuous Loko Adalat, my lord. My lord, kindly see the
you have to complete. So, many of you are not complying the defects at all. Defects be cured. You say list on 23rd June, defects be cured in the meantime.
Oblast.
Right.
Item note 29.
At 29, promotion during pendency of vigilance case, your lordship's order dated 11th of May. That will cover this case.
But service is over.
Yes, no, my notice has not gone.
We'll have to. Can't be ex parte, sir.
No, my notice to go, my
notice returnable. July 25th. There shall be stay of impugned order till then. All right.
Item note 30.
Item 30 and 31. Similar matter, that is WPC number 2436 of 2017 has been dismissed, but that order has not been uploaded, so I cannot get that copy of that order.
When was it dismissed?
That was dismissed on 18/5/2018, my lord. 18, my lord.
Okay.
That has not been uploaded. So one part of the order is uploaded, that adjournment order is uploaded, the disposal order is not uploaded.
No, it is very time. No.
That has been dismissed, my lord. So in light of that order, it can be
Disposed of. My lord. Dismissed actually. My lord.
That is
In light of the order dated 18 May 2022.
18 May 2018.
18. 18 in writ petition civil.
24361 of 2017.
Yeah. The present writ appeal is dismissed. All right.
31.
Both.
Item 32, my lord, 14th of September, job contract April.
Job contract, 14th September.
Item 33. 33 is a part of a batch matter, my lord. Writ appeal number 1280 of 2022, lordship wide order dated 1/3/2023 has been pleased to issue notice, and that has been adjourned to 31/8.
All right. Notice 31/8. Stay. There is a stay, right?
Yes, madam.
Dispensing with is allowed. Delay is condoned.
Item 34. 34 DLR regulation 14th of September, madam.
Or 14th September.
Item 35.
35 my lord, rehabilitation 30th August.
30th August.
Item number 36.
Old pension scheme 25th September. My lord.
Right.
Item 37.
Rehabilitation 30th August.
Right.
Item 38.
38 old pension 25th September.
Right.
39.
39.
Rehabilitation estimate 30th
August.
Item 40.
Item 40, my lord, I pray, my lord, you taken up after vacation, my lord.
All right. At the request of counsel, the appellant list on 23rd June.
Obvious, my lord.
For admission, item 41.
Is relating to getting land free of premium, constructed building with 42 lakhs from the MP LAD fund for the old age home, using the same as a commercial purpose as a hotel in Hanuman Vatika, Raurkela. Now the municipal commissioner, they have filed an affidavit saying that they have constituted a committee who visited the spot as per direction of the Honorable Court in the last window. And they say that only there was 18 rooms, one room is only open, other rooms are closed. There was a nameplate old age home is written, but one person was residing. He said that only month of Kartik, some people come and use there for a month and go back. Now this has been, this construction started in the year 1996, ended in probably 2000, 2001.
Madam, I am for the Melody.
What happened, sir? You have to file an affidavit.
Yes, my lord, I have filed an affidavit. Let's see.
When?
I am for Melody on the 8th May, my lord.
It's not on record, sir.
And I'm given my reply to such affidavit.
When, sir? Here. You are filing your reply.
Yes, madam.
This nothing is come on record, sir. The affidavit dated 8th May 2023 of the Rourkela Municipal Corporation be brought in record. Mr. Jena has handed over the rejoinder to the said affidavit in court today.
I am for OP number 1, your lordship.
List on 23rd June. All right.
42.
42, my lord, as per the last order, my lord, we have filed the consolidated petition, my lord. And for rejoinder, we have taken time, my lord. So after maybe taken up after vacation in between.
All right. Rejoinder to be filed before the next date. As a last chance. See list on 18 September.
Oh, bless me.
I think we'll have it up some other day, sir.
Item 43.
You can tell the other side. We'll have it on some other day. The affidavit's been filed, sir?
Yes. Mr. Tripathi is there.
2 p.m. We'll take it.
I will inform Mr. Tripathi.
Item 44.
My pleasure, Lordship. Lordship, the PIL is regarding upgradation of road from PWD Road to Palasa Chak to NH 57 by Rajanpadi and Panwase in the district of both. Lordship, the proceedings in this case is already completed. And your Lordship may submit a cert written notes so that the matter can be disposed of today.
You were to file rejoinder, what happened?
Lordship, rejoinder already filed and copies are.
When?
Lordship, rejoinder is filed.
Acha. All right.
Yes. Lordship, kindly have a glance to Annexure 9 at page 32 of the writ petition. Page 34, Annexure, sorry, my lord, page 32, Annexure 9. After considering the recommendations made by MLA, MP, Speaker, opposition party leader, and of course, on public demand, the state government declared the proposed road as other district road and directed to hand over to the PWD. Let's now kindly have a glance to the counter affidavit filed by the opposite party number 1 and 2.
So instead of closing the petition, it's better to keep it pending so that they complete the exercise, sir.
Yes, madam.
It appears from the note submitted by the petitioner that 1585 feet of government land and 1153 feet of private land is yet to be the road over so-and-so private land is yet to be completed.
Yes.
Since it is awaiting handing over the land by opposite party number 3 to the PWD. And further that the sanctioned amount in that respect is still pending with the government. Paragraph. The time-bound plan for completion of the above unfinished stretches be submitted to this court by the government by way of a supplementary affidavit before the next date. List on 25th July.
Item number 45.
In item number 45, your lordship, let's see the last order. On 24/4/2023. Last order in WPC 27133 of 2022, order dated 24th of March 2023.
Yes.
Your lordship have been pleased to almost put a quitus to the dispute. If your lordship see the order, your lordship has quoted the report that due to upcoming new project, Canals Symphon, at obstinate prohibition of movement heavy loaded vehicle over the flood protection embankment, further continuance of the source is not prudent. So taking note of that, Lord, I make a submission that let them refund my money which they have already taken from me, and they have executed the agreement with me also. So Mr. Mahantil,
I have already instructed them. I have not received any instruction. Your lordship, reopening in the meantime, everything will be complied.
Mr. Mohanty seeks some more time for instructions. At his request, list on. August 3rd.
Item 46.
And here, the order of the Honorable Single Judge has been under challenge, where a revision has been entertained after 27 years of the order. But I had given two clear decisions of this Honorable Court that it is not a matter of rule, a matter of course that it will be entertained. The Honorable Single Judge is aware. Page 20, if your lordship kindly sees, of the impugned order, it is true that the learned commissioner did not record any finding as to whether the long delay in facts and circumstances of the case was reasonable or not. But from the facts.
So this response 2, 3, 4, and 5, they've been served?
I don't know.
I'm appealing for opinion number, respondent number 2 and 3, ma'am.
What about 4 and 5?
Take out notice.
Fresh notice be issued to respondent. 4 and 5. All right. While Mr. So-and-so appears for response 2 and 3, Commandant appears for response 4 and 5 despite service of notice. There is no interim order here, is there?
No.
No interim order is there. One, the record also shows that one Mr. Budiram Das, advocate, had entered appearance for OPs 4 and 5. the registry will telephonically inform him to remain present on before the court on the next date. Interim order to continue. List on 13 September.
My learned senior may serve copy. On the last two occasions, direction has been given to serve copy to us.
Read else.
There is no interim order.
Huh? There is no interim order. But there is an interim order. There is an interim order, sir.
My lord, my
Yes.
lord.
That's, I thought I was wrong.
Right.
Sorry.
Oh, please.
Item number 47.
Notice to go in the matter of substitution, setting aside abatement and condonation of delay. Principal respondent number 1 has died in mid.
Okay. This IA is allowed. Delay is condoned. The abatement is set aside. Respondent number 1 is substituted by his LRs. The consolidated cost title is taken into record. Fresh notice to these. You are appearing? Anyone appearing? Fresh notice now to the LRs of the respondent number 1.
Millard, interim order to continue.
Returnable on 13 September, interim order to continue.
Obliged.
Item number 48.
48 can be taken up after vacation. All right. The request of counsel be applied. List on 3rd August.
Item 49.
Lordship, I am for the appellant. I pray for time to file the reply to the affidavit filed by the respondent number 2, Lordship.
Rejoinder, you mean?
Yes, Lordship.
Rejoinder be filed for the next date. List on 3rd August.
Lordship, interim order continue.
All right. Interim order to continue.
Item number 50.
May I please, your lordship. Here, my lord, I am challenging the order of the Honorable Single Judge, my lord, where the respondent filed a writ application against the order of permanent continuous Loko Adalat, my lord. The said writ application was allowed on the ground that the permanent continuous Loko Adalat has no jurisdiction to decide the partition suit. And another point, my lord, that my lord, before going to the merit, my lord, this writ application has been filed after 16 years of the order passed by the permanent continuous Loko Adalat. And the Honorable Single Judge, without considering that aspect, he only disposed of that writ application on the ground that the permanent continuous Loko Adalat has no jurisdiction to decide the partition suit. My lord, kindly see the impugned order annexure 3, running page 47, my lord. My lord, paragraph 2, my lord.
But that order, the permanent Loko Adalat in 2006, sir.
6, my lord.
And you filed the writ petition when?
No, the respondent filed the writ application.
Oh.
After 16 years, my lord.
It is seen that the impugned order, you say none appears despite completion of service of notice on respondents 1 to 12. Paragraph. The impugned order the single judge has set aside in a writ petition filed in 2022 an order the continuous and permanent Loko Adalat (CPLA) passed way back on 14 July 2006. Stop. It is obvious the petition was delayed by 16 years. And this fact is also noted by the learned single judge. Stop. However, on the presumption that the respondents were unaware of the above development, the order of the CPLA has been set aside. Paragraph. With the learned single judge ought to have first examined the question of the obvious delay and latches in filing the writ petition and should have called for a satisfactory explanation for the inordinate delay. Stop. With that step not having been completed, it was erroneous on the part of the learned single judge to proceed to deal with the writ petition on merits and allow it despite the petition being barred by laches. Paragraph. Accordingly, the impugn order of the learned single judge is ever set aside. The writ appeal is allowed no order such cause.
Oblige me.
Same.
Item number 3.
Let's see permission to raise all the
All
points.
right. Same.
Item number 4.
None of this dismissed.
Item number 5.
Same.
Item 6.
Same.
Item number 7.
Permit to withdraw and raise the point permitting case.
Item number 8.
May I please, my lord? This is a default bail. Similar situated co-accused. Similarly situated co-accused persons have been granted bail and fairness has been allowed by them. But under the law, before expiry of 180 days, the IO has to file petition and the PP has to file separate petition. And the ground stated, the IO has to assign the reasons regarding the progress of the case. So, similar situated accused persons have approached this honorable court in CRLMC and they have been granted.
No, similar, this same case.
Same case.
But should we kindly see my lord?
What is this order such? Order granting bail.
Yes.
Well, default bail.
Anyway, what is this order? What are you coming here?
Well,
what is the prayer here?
Prayer to quash the order.
How is the both is similar? Quashing can't be similar to
the
default bail. What is this? You can't confuse things like this, sir. Somebody got default bail and you want quashing. It's the same thing for you.
And that is default bail, my lord.
On that basis, this case itself should be quashed. What is his argument?
My lord? My lord, points of this case is that before expiry of 180 days, the special PP through IO filed a petition stating that.
What is your prayer in the present petition?
To set aside the order.
To set aside the.
He is challenging order dated 1/3/2021.
To set aside the order dated.
That is page 40.
Page 13, my lord. Page 13. It is therefore humbly prayed that this honorable court may graciously to set aside the order dated 1/3/2021 passed by London Sessions of Constitution Malkanagiri in TR case number 89 of 2020.
Page 40 is the impugn order.
And to allow the petitioners to go on bail.
You want to check out this?
Page 40 is the impugn order. What has happened, my lord? Before the time period expires, the IO has filed an application for extension. That was allowed.
Refused.
Further extension of 60 days was given. Within that period, the charge sheet has been filed. Now, his ground is that he is entitled for default bail. The judgment which he is showing for another single judge, my lord, therein the honorable court.
There is some Supreme Court judgment now on this.
Yes, but that says that in case the notice of that extension of time period application.
Just examine the Supreme Court judgment. There are two conflicting orders, if I remember right.
Yes, my lord.
The counsel for the state seeks time to examine the Supreme Court judgments on default bail in the context of the NDPS Act.
Yes, madam.
Yes, madam.
At his request, list on 27th June before the roster bench.
Madam, I may pardon.
7 June.
27th June. Item number 9.
This matter has already been in flux.
All right. In fact,
So may kindly be permitted to withdraw.
all right.
Item number 10.
None of this.
Item
None of
11.
these were the petitioner dismissed. All right.
Item 11.
None of this dismissed.
Item 12.
Same order.
Item number 13.
13, 14, 15.
14, 15. Item 16.
Same order.
Item number 17.
Same order.
Item number 18.
Same order.
19.
Lord, kindly taken up after vacation. File is misplaced.
Misplaced means easier, sir. Counsel for the petitioner states the file is misplaced, dismissed for non-prosecution with liberty to revive it in case file is found for it.
Madam, oblast.
Item number 20.
20 madam, no
Same.
instruction. No instruction.
No instruction dismissed. All right.
Oblast.
21.
None of case dismissed.
Item number 22.
None of case dismissed.
23.
Item 23, your lordship's liberty may kindly be granted to
All
the
right.
resolve.
Permitting the petitioner face out, please.
Obliged, lordship.
Item number 24.
Liberty may be given, my lord.
All right.
Item number 25.
None of case dismissed.
26.
None of case dismissed.
Item number 27.
Same order.
Item number 28.
My lord, I will take notice on opposition 2 again. He is residing with me. I will produce.
Fresh notice to opposite party number 2. Thus
I married her, my lord, and resides. She is residing with me.
All right. Returnable before the roster bench on 28 June. All right.
Item 29.
None of case dismissed.
Item number 30.
Same order.
31.
Same order.
32.
Same order.
33.
Same order.
Item 34.
May I please? Yes.
Item 34, my lord. In this case, my lord, FIR was lodged against one Joga Behra, son of a Bhubaneswar Behra, my lord. Charge sheet submitted against one Joga Behra, son of a Haradhar Behra, my lord. My name is, my lord, Tilochana Behra, son of a Krishnachandra Behra, my lord. But in fact, my lord, the petitioner belongs to Kotak, my lord. He residing there, my lord. The brother of the informant was Sarpanch in that locality, my lord. He threatened the petitioner to leave the property, hand over the property to the informant, my lord. According to that, dispute, my lord. In fact, the son of the informant, while going to the shop, it is alleged that one Joga Behra taken him and committed unnatural offense with the son of the informant, my lord. That's the allegation, my lord. With regard to the petition is concerned, my lord, only because the petitioner came to this honorable court, the police repeatedly searched his house, my lord. His name is Joga Behra, son of my lord, Krishnachandra Behra, my lord. In fact, my lord, in the cognizance, my lord, as page 18, you can see 16 page, my lord. Ordered 25/9/22, my lord. At 2020, the case record put up today on receipt of the preliminary charge sheet number 184, 23/9/2020, along with the case diary, statement 161, statement of witness, seizure list, Jimanama, other connected paper on perusal of the FIR charge sheet submitted on 161 witness, including the victim boy, 164 statement of the victim boy, as submitted by the IO, sufficient disclosure prima facie case showing completion of the accused Joga Behra, my lord, not the petitioner, my lord. Since petitioner repeatedly searched the house of the petitioner, my lord, in connection with the present case, my lord, and left a message in her for
What do you say, sir?
My lord, Joga Behra, my lord.
Joga Behra?
Yes,
my lord.
Oh.
In fact, there is no such occurrence, my lord. The petitioner has no shop there at all, my lord. And the occurrence, alleged occurrence taken at the shop of Joga Behra, my lord. Cognizance taken against Joga Behra. And son of another person, my lord, not the father, my lord.
But why have you come? Because if
my lord, the police, my lord, the elder father of the victim, my lord, the brother of the informant, the local sarpanch, my lord.
No, no, what is this 25th September order? Where is that?
My lord, 25th cognizance, my lord.
Oh, cognizance taken against you.
No, against Jaga Behra.
No, why are you here, sir?
But the police, my lord, repeatedly searched my house, my lord. For that reason.
No, but what is the prayer then? Why are you asking for setting aside the order of taking cognizance against Jaga Behra?
Against Jaga Behra, my lord. My lord, for that reason, my lord, my lord, the government council member.
You are not Jaga Behra, sir. Why do you want to seek quashing of an order against Jaga Behra?
Only because, my lord, the petitioner.
No.
The police, my lord.
You're seeking benefit for somebody else. If today this prayer is allowed, come to your prayer clause. Suppose I allow this prayer. Jaga Behra has not come to this court. At your instance, the order taking the cognizance against him is being set aside.
That order may pass your lordship. As because my lord, file here, my lord. Only because, my lord, IO had to explain how the petition is implemented. They repeatedly sought the house, my lord.
What is a prayer? You're here to
the cognizance, my lord.
So,
the police
prayer, if it is allowed, whom will it benefit?
Police, my lord, saying that the petition is the Jaga Behra. But, my lord, in this can see the charge sheet, my lord. Father name is different, my lord. In charge sheet, I have annexed, my lord. Tilachana name is implicated, my lord.
Sir, your prayer has to be clear.
My lord.
If you say you're not Jaga Behra, you can't ask for quashing of an order against Jaga Behra.
My lord, only because, my lord, the police in the charge sheet added Jaga alias Tilachana. Yes. For that is, my lord. Jaga alias Tilachana, for that is, I am committed to this court, my lord.
Tell us whether this man is Jaga Behra or not.
Yes, I will take instructions, my lord. Yes,
Counsel for the state wants to take instructions on whether, as claimed by the petitioner, he is not single quotes Jaga Behra. List before the roster bench on 7th August.
Oblige.
Item 35.
My lord, in this case, my lord, the notice has not been solved.
What is the matter about?
My lord, it is a case of 138. It is a violation of section 138B and 141.
Or you can point out to the trial court.
No, my lord, kindly have a glance, my lord, because it is a matter on the Hada case, my lord, where the accused, the drawer of the check is the farm, my lord, and the case has been filed in the personal capacity, my lord. That is, my lord, kindly have a glance on the check, my lord, which is page number 34, my lord.
So this respondent is not served at all.
Yes, my lord. Notice has been issued, but it has been returned, my lord.
Nothing is happening in the complaint also, sir. This, whatever you are saying, can be pointed out to the trial court.
My lord,
there's enough case law, no, all that.
My lord,
there's a lot of case law on this, sir, now.
My lord, I know, my lord, but my lord, it is a...
If the other side is not served, we can't simply proceed in the matter.
No, my lord, I want to, my lord, let the notice be solved again, my lord, because my lord, notice has been returned, my lord.
Endorsement is always absent.
My lord,
obviously, when the matter is called out to the trial court, nobody will appear. That will be the end of the year, matter.
No, my lord. No, my lord. In the trial court, my lord, the complainant has been appeared, my lord, and the case has
when was the last hearing?
My lord, on the next date, my lord, on 1st July 2023, my lord. Case has been posted for, my lord, an evidence affidavit, my lord, and the complainant is present, my lord. Complainant is pursuing the matter in the trial court, my lord. Only, my lord, my prayer is, my lord, let the notice be solved again, my lord.
It is claimed that the complainant is still appearing before the trial court, and the next date is 1st July 2023 for recording of evidence. So stop. However, the endorsement in the notice sent by this court to the opposite party is open quotation. Always absent, return to center, unquote. Permitting the petitioner to serve the opposite party in the trial court.
Well,
when the matter there is taken up on 1st July 2023,
well,
fresh notice is issued,
well,
returnable on 7th August. All right.
Well,
Item 36.
May I please, Lordship? Lordship, in this case, the informant wife lost the affair against the husband under section, Lordship, 498A, 294, 323, and 506. And Lordship, and on that ground, he is on bail. But Lordship, charge sheet has been filed under section 307, Lordship. And 307 is not made out. And my humble submission is, by adding this section, Lordship, if he appeared before the JMFC, then he remanded to the session judge, Lordship.
So what?
So Lordship,
Wherever you have to argue for discharge only.
Lordship, I need some protection.
No, this is not the matter.
And Lordship,
this
kindly,
is not the forum for that, sir.
and Lordship, kindly glance at the 307 is not made out, Lordship.
That
And
you
that
point
is-
out to the trial court. You point that out.
And they have blessed with a child, and Lordship, after 9 years of marriage, she lost
You
the
either
affair.
get an affidavit from her saying that you've settled all your disputes, or you argue all this before the trial court.
Lordship, then kindly grant some
Permitting
time.
the petitioner to raise all pleas at the appropriate stage. All right.
Item 37,
None appeals dismissed.
38,
Same order.
39. Skip.
39 is your case.
Yes,
sir?
my lord, yes. My lord, the vehicle was seized for commission of the forest offense, my lord. My lord, section 56, my lord, provides, my lord, the criminal court has no jurisdiction, my lord, to when the confiscation proceeding is pending. So, Lordship, may kindly see the
What is the vehicle, sir? What is the vehicle?
Vehicle, my lord, JCB, my lord, JCB. And also that is pending with the department. And that has not been released, my lord.
No stay granted by this court. You still not released it.
My lord.
There is no stay granted by this court.
No, my
sir.
lord. My lord, for the
You have
first
still
time-
not complied with.
My lord, the vehicle has not been released. That is pending with the department, my lord. And also, your Lordship, may kindly, the confiscation proceeding is pending before the authorized officer.
Yes.
And this
Enough
petition,
conditions, enough protection is there. The impugned order has been produced. There are enough protections built into the order, which will not prejudice the case of the petitioner, even if the vehicle is released. The court therefore declines to interfere. The CLLC is dismissed.
Item number 40,
None appears dismissed.
item 41,
May I please, the Lordship? Lordship, 27, item 27.
What we have called out is 41, no?
41.
Lordship.
Are you appearing in 41?
Yes, yes.
What is 41?
41, Lordship, this is the case of 376, 417 and 493 IPC. Lordship, the cognizance was taken by challenging the order of cognizance. Cognizance should have been taken by a juvenile court, but it was taken by the.
Where is the proof of your juvenility?
It is there in the FIR, Lordship. Ali, there was law when the incident took place 3 years back. At that time, I was 20 years of age as per the FIR. I was having love relation with the major girl.
So your Lalita Pradhan.
Yes, Lalita Pradhan.
Your age is 31 years.
Not 31, it's erroneously written as 31, it's 20 years. Actually.
In a matter of juvenility, you erroneously write 31 years. This is remarkable, sir.
Later on,
so you're so careful. In a matter you're pleading juvenility, in cause title, you put your age as 31 years.
In para 9, it's been mentioned.
Sir, if you're so careless, why should we bother all this? You're so utterly careless. In your cause title, next to your name, you say 31 years. And you're arguing juvenility.
It was a typographic error.
So simple. So simple.
in the FIR, my lord, it has been stated 20 years, my lord. In the
20
FIR.
years.
How is 20 years juvenile?
No, my lord. 3 years back incident.
You take
the
all
continuous
pleas.
law paper.
No, sorry. Permitting the petitioner to raise all pleas at the appropriate stage. How can you be so careless, sir? Your pleas juvenility, typographical error. Amazing.
Copy paste.
Right.
Item number 42.
Item 42, Lordship. Alice offense of 498A, 304B, 302 and 34. Charge sheet was filed under section 304B and 306.
Permitting the petitioner to raise all pleas. All right. Which is that other item you're mentioning? 20?
27, Lordship.
What do you want to say in that?
Lordship, it is a case of illegal excavation and transportation of lateral stone. Petitioner is implicated only basis of the statement of the co-accused
Same
person.
order. In 27, you say permitting the petitioner. All right.
Item number 43.
Under 43, here the parties have solved the dispute. Well, the affidavit is ready, but the
informant could not come and swear the affidavit.
All right. Counsel for the petitioner states that the affidavit of the informant will be produced on the next date. Let's move to the roster bench on 7th August.
My lord, interim order.
All right. Interim order.
Item 44,
None appeals dismissed.
45,
Same order.
46,
Same order.
item 47,
Yes, same order.
item number 48,
Same order.
49,
Same order.
item number 50,
50, my lord, not press.
Dismiss is not pressed.
item 51,
51, lordship permitted orders.
Dismiss is
52,
May I please, your lordship? Here, my lord, the petitioner challenges the impugned orders under Annexure 2 and 4, my lord. Under Annexure 2, dismissing the petition of the petitioner under Section 457 of CRPC for release of seized tobacco product, my lord, which was confirmed by the London District Judge under Annexure 4, my lord. Grounds for challenge is that, my lord, the mandatory provision under Section 13(2) and Section 18(1) has not been followed in the instant case, my lord. My lord, seized tobacco was seized only on 29/11/2020, my lord. Thereafter, petition for release of the seized article was filed on 17/3/2021, much after 90 days, my lord. Section 13(2) and Section 18(1), my lord. Section 13, subsection 2 states, no package of cigarettes or any other tobacco products or advertisement material seized under Clause A of subsection 1 shall be written by the police officer who seized the package.
What does the chemical examination report say?
Chemical examination report had not been obtained. That is also reflected in the order.
What is the position today, sir?
Page.
Chemical examination report.
Lord, so far the chemical examination report, my lord,
You better find out if it is now at least available, sir.
Yes, my lord.
Counsel for the state will ascertain if the chemical examination report is available, and if so, produce it before the court on the next date. A list on 3rd July for the roster bench.
item number 53,
None appeals dismissed.
54,
Same order.
item 55,
Same order.
item 56,
Same order.
57,
Same order.
item number 58,
Same order.
59,
59 may I click, Lord. Challenging the order of cognizance, Lord, under Annexure 2, Lord. Lord, cognizance was taken under Section 1, 419, 420, 467, 468, and 471, 120, and 34 IPs, Lord.
Charge sheet file, sir.
Charge sheet, my lord, file. Yes, my lord.
Then you raise all these, permitting the petitioner to raise all these.
I beg pardon, Lord.
We permit you to raise all, please, sir, at the appropriate stage. All right.
But
item number 60,
420 is not made out, my lord.
You point out to the trial court, sir. No problem. Yes.
60. May I please, your lordship?
Yes.
If the case is the year 2010, your lordship, the FIR at page 9, my lord. Then charge sheet file at page 15, my lord. Then cognizance taken on the date 13/10/2010, my lord.
What is the
at page
offense, sir?
29, lordship. Then after filing of the charge sheet, trial commenced.
498A. Huh.
Yes, lordship. Opposite part, the witness number 1 and 2 was wife and mother-in-law, my lord, mother of the informant, my lord, and they have been put into decline, my lord. Now, the present petitioners have filed a discharge petition, but it has been rejected, my lord. Now it is pending for further witness. No witnesses are coming to the court. The prosecution is failed to bring the witnesses, and witness number 1 and 2.
You ask for expeditious trial, sir, that we can do.
With the time bound, if they are not coming, then
since the trial is in progress, the prayer is that it should be concluded expeditiously. Full stop. The direction is issued to close the prosecution evidence after examining all the evidence, witnesses positively by 1st September 2023, and defense evidence within a month thereafter. The final judgment will be pronounced not later than 1st November 2023. A copy of this order be sent to the concerned court forthwith. It is made clear that both prosecution and the defense should cooperate with the trial court in adhering to the above targets. The petition is disposed of.
Item number 61.
61, my lord, I pray for some time to remove the defects, my lord.
What's the matter, sir?
Matter is, my lord, for passing of the cognizance order dated 22/3/2027, my lord, taken under section 498A, 406 and 34 of IPC, my lord.
Raise all, please. Raise all, please, sir. Permitting the petitioner. Raise all, please, at the appropriate stage. All right.
Item 62.
Permitted to. Permitting to raise all, please. Right.
Item 63.
Permitted to withdraw in the memo.
All right. Dismiss this withdraw. Memo taken.
Item 64.
None of this dismissed.
65.
Same order.
66.
Same order.
Your Lordship, I am appearing in item number 66, my lord.
Yes, please.
Wait, please. My lord, the petitioner praying for modification or alteration of the condition imposed by the learned session judge, Your Lordship. Your Lordship may kindly peruse page number 26 and 27, my lord. That is the condition imposed by the learned session judge. The present petitioner obeyed all the conditions, my lord. But in this matter, my lord, the present petitioner praying for modification and alteration of condition because, Your Lordship, till December 2022, the petitioner managed his vehicle and now it is laying in front of his house, Your Lordship. And his
What is the modification you want?
He want to sell his vehicle to a law-abiding citizen and that person also obey all the conditions, Your Lordship. The petitioner want to sell his vehicle to a person, Your Lordship. That person also obey the conditions.
Which is that person? Which person? Which person, sir?
My lord,
whom do you want to sell it to?
I want to sell my vehicle, Your Lordship.
To whom, sir?
To a person, Your Lordship. If
a person is who?
Till date not ascertain, Your Lordship.
So imaginary person.
No, not imaginary, Your Lordship. If Your Lordship allow me to sell the vehicle.
Without knowing who we want to sell it to. Very nice prayer, sir.
No, my lord.
Actually, excellent prayer. You yourself don't know who you have to sell it to. We have to permit you to sell.
Yes, one person is there, my lord.
Where? Which person is where?
I have not filed any details of that person.
Whenever you get those details, you file these petitions.
If Your Lordship, I will amend the.
No amending. No. First, this is not one taking a chance. If the court asks you a question, then you furnish. It's not like that, sir. Sorry,
no, my lord, because there is a
now we don't want you to now go start hunting for some person to sell.
No, my lord. Your Lordship is correct, but my lord, the condition is there.
No,
that if,
you say the person
is
if you're not withdrawing, well, you listen to the order now. The petitioner.
No, my lord. Your Lordship may kindly raise all the point before the learned session judge.
What is that? What is all these points? It's not some caution. It's only for release of vehicle.
No, vehicle is with me, Your Lordship. I want to alteration or.
Anyway, this is not for. Okay. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to seek appropriate remedies in accordance with law. This post of its withdrawn with liberty is paid for. All right.
No, 67.
Notice it later.
67.
None appears dismissed.
68.
None appears dismissed.
Item 69.
Wait, please, Your Lordship. In item number 69, Your Lordship, another matter is pending, my lord. That is CRLMC number 1454 of 2023. Dr. Guruswamy appearing in that matter. My matter also similar to that matter, Your Lordship.
Where is it coming up?
10th July, Your Lordship.
List on 10th July along with criminal MC?
1454 2023.
All right.
Item 70.
May I please, my lord? Lord, this is the case of Belgium, my lord. Page 13, my lord. NBW issued to me on
NDPS Act.
under the 10/1/20
NDPS Act, my lord.
2023 order, my lord.
Yes, yes. So NDPS Act, I'm not passing this one.
My lord, not intentional, my lord, and order is 2023, my lord.
No problem, sir. You have to serve. Considering that the offences under the NDPS Act, court is not inclined to interfere with the order, the impugned order. The petition is dismissed.
Only one sense may be given, my lord.
71. 71.
None appears dismissed.
Item 72.
Lordship, permission to it.
Dismisses with problem.
73.
May I please? My lord, petitioner is a lady, my lord, praying for release of a motorcycle, my lord. Motorcycle was in your name. Some person was taken her motorcycle and also carrying a 9 liter of ID liquor, and the vehicle was seized by the excise team since long, my lord. I pray for a release.
What is the ground on which it was refused, sir?
My lord? Ground, my lord, she is not accused in this case, my lord. She is the owner of the register, owner of the motorcycle, my lord. Vehicle was taken one, my lord, complete.
What kind of
Excise
this is item number 73? 28 June, right, before the roster bench.
Ashish Ranjan Mohanty, my lord. In the light of Ashish Ranjan Mohanty, my lord.
In the light of?
Ashish,
No, but the pages are themselves not clear, sir. All jumbled up.
Yes.
Yes.
My lord, Arjun, my lord.
Arjun to 28.
Defects have to be cured, sir.
Yes.
Some pages are unreadable. Yes.
Item number 74.
74, lordship.
Yes.
Lordship, item 74. But the matter is dismissed, my lordship, due to non-appearance of the complaint.
What is the main matter about?
Main matter, lordship, in fact, there are cognizance in both. There is a case in the police station and in the complaint case. For self-same occurrence, there are two cases, lordship. This is one criminal miss case, and other criminal miss case is 530/2021, lordship. And for the self-same occurrence, twice cognizance taken. So that is under challenge, lordship. Both the applications may be clubbed to get together, lordship.
When is that coming up?
Lordship, in fact, that is pending. That is no date 530/2021.
All right. List this application itself along with criminal MC
530/2021, lordship.
Before the roster bench on 8th August. All right.
Grateful, lordship.
All right.
Item number 75.
My lord's item number 75 has become infructuous.
Okay. Dismiss this infructuous. All right.
76.
May I play, lordship? On behalf of provision, lordship. The matter, lordship, 120, 467, 468, 471, 422 IPC, lordship. In this matter, lordship, the petitioner taken a loan, lordship, in 1999, lordship. He has paid the amount, but due to the default, he has not paid. The loan amount was, lordship, OTS was allowed. In the meantime, the bank was liquidated. He has not paid the loan amount, lordship. In the meantime, FR is lost and he has been arrested and he has been released on bail. In the year 2016, FR is lost. Till date, the charge sheet has not been filed, your lordship.
We'll ask them to file
And he has already retired, your lordship.
All right. We'll ask them to file it immediately, sir.
Yes.
Lordship.
We'll ask them to file it immediately.
Well, yes, my lord.
The grievance of the petitioner is that charge sheet has not been filed. A direction is issued.
My lord, the large number of loanies are there, my lord. Therefore, the investigation is going on. Therefore, your lordship may give some time, my lord, more time.
Lordship, it's a 2016 matter, sir.
Yes, your lordship.
Already
retired, your lordship. Has not...
The occurrences in 2016 and the petitioner has already stated a superannuated. A direction is issued to complete the investigation and file the charge sheet not later than 1st October 2023. No further directions are called for. It will be open thereafter for the petitioner to raise all the pleas at the appropriate stage. The petition is disposed of.
Item 77.
None appears dismissed.
78,
Same order.
79,
Alerts, I came running. I thought that the matter will reach after recess. But to my surprise, when I reached this floor, I found that it is 66. Then immediately I called for the file balance.
Now, this is the age of Vande Bharat.
Mallards?
This is the age of Vande Bharat.
Yes, my lords. But I am retiring, my lords. So therefore, this will not. Lordship,
yes.
Similar type of matters.
Yes.
Lordship knows that vicarious liability under the Factories Act.
Right.
Only the person without the company has been implemented.
I know. So Factories Act, I've asked for
Boilers, Factories and Boilers Act.
So that occupier, that has to be in a different principle.
Yes. Yeah.
So you examine it, sir.
Yeah. Lordship have fixed it to 31st of July. Lordship is always fixing it.
Correct.
Interim order to continue.
Correct. Interim order to continue, list of 31st July. All right. All right.
And I must say, Lordship have a good vacation.
Yes, you too. Badly needed for all of us.
Yes. So because of the hot summer.
Correct.
Yeah, much obliged, man.
All right.
item number 80,
None appears dismissed.
81,
Same order.
Maybe Lordship. Your Lordship, the petitioner, the father of the opposite party number 2, Lordship. Your Lordship, opposite party number 1 happened to a father-in-law, Lordship. He claimed a maintenance under Annexer 2, page 10, Lordship. And I am challenging order dated Annexer 3, page 17/8/2021. Your Lordship, DW has been issued against the area maintenance sum is their Lordship. In the meantime, last time, court says that pay some money. I prepare a draft. Office party pay some money that will hard this matter. I prepare a draft rupees 15,000. Yes, opposite party. You Lordship, I am the natural guardian of the opposite party number 2. The Guardianship Act is pending under Annexer 1, Lordship. Till it was not disposed of. I am ready to maintain my child. I am ready, and Lordship, the opposite party number 1 honestly harassing me by filing all these things, Lordship.
Who is appearing for opposite party number 2?
Lordship.
Mr. Behra. Where is he? Mr. Shanti Ranjan Behra. Counsel for the petitioner states that he is ready with the demand draft in the sum of
15,000. I have a draft.
50.
15.
15. What are the arrears?
Lordship, the area is there 75,000.
You're paying just 15.
Lordship, I will pay some more also.
What? Why you being very charitable? Is it? You think you're doing charity?
Court says that
you have to comply with an order of the court. You're making it appear you're doing some charity.
Lordship, in the meantime, I pay some money, Lordship. That court says that you say some other.
What is the consequence of not obeying a court order, sir?
Lordship, here, Lordship, immediately I am the natural father guardian of the opposite party number 2. I am ready and willing. They are not allowing.
You are not in a suit for specific performance.
Lordship,
all right.
Lordship.
In that kind of suit, you can say all this.
Lordship,
you are now against an order which mandates you to pay maintenance.
I will.
No point saying I will. Where is the money?
Money, Lordship, I have prepared a draft, Lordship.
For what amount?
Lordship, here, Lordship, 15,000.
That is not good enough, sir.
30,000 I will pay. Till disposal of after hearing this.
That you tell the trial court. All right. You say the petitioner has come up with a measly sum of rupees 15,000 as a demand draft, whereas what he is required to pay under the impugned order is well over rupees 70,000. Stop. This does not demonstrate the bona fides of the petitioner. Consequently, the court is not inclined to appear. The matter be listed before the trial court on 3rd July 2023, on which day the petitioner should appear and comply with said order. The interim orders are vacated. Copy of this order be sent immediately
I pray
to the concerned court.
Let him appear opposite party till next week. I will
Lordship, I have here a disposal, Lordship.
So go there, you pay the entire amount, it will all get settled. All right.
82. From 82.
No, please dismiss.
Item number 83.
83, my lord, Mr. BP Tripathi will argue this matter kindly pass over after launch.
What's the matter about, sir?
Matter, my lord, here the petitioner is a project director of the construction company. The complainant filed a complaint case.
What's the service of?
Alleging, my lord, unauthorizedly dig out of earth from his plot. Thereafter,
For opposite party number 2. One Mr. G.K. Mahanti is shown appearing for opposite party number 2. He's however not appearing today. The registry will inform.
My lord, I am for the OP number 2, my lord.
What is your case, sir?
My lord, the petitioner has dug 22 feet earth from the agricultural land of the opposite party number 2 without his consent, my lord.
matter has been investigated by the police, my lord, and a charge sheet was submitted. And thereafter, my lord, again he has filed this protest case. Not real culprit has been nabbed, my lord. Nothing remained to be investigated or decided further, my lord.
Your lordship may kindly see page 22. That is at the charge stage, my lord.
Oh.
Page 22, my lord, your lordship.
All right. You say permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. The interim order is vacated. All right. Copy of the order be sent to the concerned court forthwith. Right.
84.
Lordship. Your lordship, matter has been settled between the both the party, lordship.
Affidavit already filed, lordship.
Flag B, lord.
What are the offences?
498, lordship. Thereafter,
We have counsel appearing for opposite party number 2 confirms the affidavit jointly filed with the petitioner, stating that the parties have already settled all their disputes. To stop the marriage between the parties is got dissolved, and the permanent element is also being paid.
Yes.
That view of the matter, it takes from the prayer clause and all consequent that to a hereby quashed. All right.
Obliged. Item 85.
In 85, Lord, I am up for OP number 2.
All right. None appeals to the petitioner. You put down his name.
Item 86.
Mr. Nobaskush.
86.
None appeals dismissed.
87.
87 not pressed, my lord.
Dismissed is not pressed.
Item number 88.
My lord. My lord. I am the petitioner in this case, my lord. This case, my lord, this honorable court, my director, issue notice calling upon the opposite party to file the show cause, my lord. But till that, they have not filed the show cause, my lord. Well, how it possible, my lord, without filing the show cause, matter will have, my lord.
What is the matter about, sir? What are you challenging?
We are challenging, my lord, to quash the DV proceeding because it is not coming under the law, my lord.
Meaning?
My lord, because, my lord, it come to my lord petition, my lord. DV petition, my lord. Annexure, my lord. My page 4, my lord. Para 6, my lord. The cause of action arose in the Europe from 1998. 1998, my lord, page 6, my lord. After 32 years, my lord, they have filed. My law came in force in 2005, my lord. Prior to filing this case, my lord, however, the present petitioner also filed a 125 under the Jagatsinghpur case, my lord, same is still is pending before the Lawrence, my lord. Annexure 4, my lord. Annexure 4, my lord, there is an interim order, my lord, and to 12, 11, 17, my lord. Annexure 4, my lord. That case is pending, criminal proceeding under section 125 also filed, my lord. Prior to filing this case, my lord, they already filed, my lord, 125. Already petitioner given the maintenance, my lord. My lord, it's a decision, my lord, there, my lord, Supreme Court, my lord. My lord, the fundamental rights, my lord, a true and acute, my lord. my lord, just copy, my lord, no, otherwise, my lord, let them to file, my lord, counter, my lord.
No counter rejoined now. Yes.
This one.
Millard, I am appearing for the opposite parties, Millard.
Two decision, my lord. The constitution, my lord,
Your lordship,
22, my lord. 22 and another, my lord, it also, one CPC, my lord. One CPC, 10, man. Also there, man. In support our case, man.
Your lordship may kindly turn to the prayer of the petition, Millard, filed by the
Squashing of the DV
to
case.
quash the DV. The DV was filed in the year 2018. They have appeared and filed objection, Millard. Maintenance was order. They have not complied, Millard.
Oh, I see.
Appeal preferred. Appeal was dismissed before the Lawrence ADJ.
Okay.
Thereafter, they have come to this court, Millard, for quashing of the case.
Man, let them to file, man.
Till then, Millard, they have not paid a single pie
My goodness.
as maintenance, Millard.
Oh,
Man, whatever
what is
they,
the maintenance amount?
whatever they stated, man, let them to file counter, man.
Millard,
Will object, man.
Millard, amount is 5,000 each per month and 1,40,000 as area, Millard. That has not been paid till date. And after dismissal of the appeal, Millard, they have come to this court.
After 3 years.
My question of law is there, man.
So
In
far
my
as
favor, man.
482 is concerned, this person is concerned, Millard. That's not at all, Millard, maintainable.
Correct.
Man, the constitution 22, clause 2 and 10 CPC also in our favor, man.
Okay.
Prior to filing this case, already maintenance already filed, man. They are giving, man.
No, Millard.
And
In that case also, nothing has been
other
paid.
hand, my lord.
All right.
In other hand, my lord, law came in force, man, in Europe to 5, my lord. All the Paxor, my lord, is 98, my lord.
All right.
That is the question of a limitation, my lord.
All right.
All my lord, all limited pair, let them to, my lord, try before the Lord court below.
Counsel of the petitioner states that he will urge all the pleas raised in the present petition at the appropriate stage in the trial court. The petition is disposed of accordingly. The interim orders are vacated.
Obliged.
89.
May I please, Your Lordship? I am for the petitioner, Your Lordship.
Yes.
Due to some medical emergency, I traveled today outside. So I pray, Your Lordship, Friday or any date convenient.
Counsel for the petitioner has stated to be in some personal difficulty. Interim order to continue. Let's put the roster bench on 4 July.
Much obliged, Your Lordship. Much obliged.
Item number 90.
None appeals dismissed.
91.
91, I'm for the opposite party, my lord.
All right. None appeals to the petition. Dismissed from
Item 92.
My lord.
92.
None appeals dismissed.
92, lordship, I'm opposite party, lordship.
All right. None appeals to the petitioner dismissed.
Interim order vacated, lordship.
Interim
order
is vacated. All right.
Item 93.
None appeals dismissed.
94.
In this application, the petitioner pays for quashing of criminal proceeding, my lord. Already matter has settled between the party, my lord. Informant and petitioners are the relation.
Settle, my lord. All right. Counsel appeal for opposite party number 2 hands over an affidavit confirming that the parties have settled their disputes. In that view, the matter taken to the prayer clause and all proceedings consequent that are hereby qualified. All right.
Item 95.
None appeals dismissed.
Item number 96.
96, I am appearing for the petition of Millards.
Yes, please.
Here, Millards, it is a case. There was under section 498A of the CRPC. That's an IPC. The marriage was in the year 2003. FIR was lodged in 2019. Millards have annexed all the material evidences and page 35 onwards.
But it is in vernacular language. Will you, Lordship, permit me to translate it and file within 2-3 days?
No, no. What is the stage, sir? Charge sheet was filed and then
the charge has been formed.
Challenging the framing of charge, my lord.
it's a stage of framing of charge.
Framing of charge.
Then you can argue all this there, Mr. Das.
All right, your Lordship. I will
Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed of. All right. The interim order is vacated. All right.
97.
My lord, permitted to withdraw.
All right. Dismissed as withdrawn.
Item 98.
May I please, your lordship? My lord, the petitioner have prayed for the quashing of the criminal proceeding. My lord, the case of the informant who is the OP number 2, my lord, and had also appeared before your lordship, is that he is one of the son of the original recorded tenant. And some people like Usha Sahu, Lakshmipriya Sahu, Sthiti Pragya Sahu, Sivacharan Sahu, they, my lord, have sold the scheduled land, a piece of land, to me, my lord, the petitioner number 1. And the petitioner, we are the vendees, my lord. Petitioner number 1 has purchased the land, and the petitioner number 2 is the husband of a witness. His wife's name found place as a witness to the sale deed. My lord, my respectful submission is, my lord, even if this is a case between the original recorded tenant and his legal heirs and my vendors, how, my lord, I have been arraigned as an accused just because I have purchased the case land on the basis of a registered sale deed. ROR has been in my name. Civil suit is pending.
So what is, obviously registered sale deed, is there a 468, 471 here?
My lord. My lord.
My lord.
My lord.
No,
But my lord, I am the purchaser, my lord.
1 minute, sir.
My lord.
Is there a case that the sale deed itself is forged?
No, my lord.
What is the offense under? What are the
offenses are under, my lord?
419, 420,
463,
464, 465, 466, 468, 294,
That's what it says, 468, sir. Obviously, the documents themselves are fabricated.
The fact,
The case must be the fabricated documents.
The fact of the case is, my lord, I am submitting before lordship. The petitioner 1 and 2.
No, you tell us charge sheet has been filed.
Charge sheet has not been filed, my lord.
So charges have yet to be framed.
So lordship can see the only 1 minute, my lord. Lordship can see the annexure C by 1, C by 2.
1 minute, sir. Charge is not framed yet.
No, my lord.
So you can raise all pleas, sir. Permitting the petitioner.
When they get the ballot of my lord, they came to this court.
I am passing an order in your favor.
Yes.
And against him. All right. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. The interim order is vacated.
Item 99.
99, lordship, I am opposite party, lordship.
None appeals to the petitioner. This was not possible.
Item 100.
Interim order vacated, lordship.
Interim order vacated.
Item 100.
None appeals dismissed. Interim order vacated.
No, item number 100. Item 100.
Hmm.
100, I am the petitioner, my lord. Application for quashing of cognizance and enter criminal proceeding. The opposite party 2 complainant has appeared and has filed an affidavit along with a joint compromise petition has been filed.
What are the offenses?
379. 1000 has entered to the house.
The opposite party number 2 has appeared through counsel, and his affidavit is also on record, stating that all the disputes between the parties have been settled. In that view of the matter, the prayer clause and all proceedings consequent thereto hereby quashed. All right.
Okay. Item number 54, my lord.
Yes.
My lord, state has filed this case. This has become infructuous, my lord.
All right.
54.
54 dismissed as infructuous.
Item 51, my lord. Permitted to withdraw, my lord.
All right. Dismissed as withdrawn. 51.
No less.
All right.
Item number 43.
43 pursuant to your lordship's order, my lord. Both the CDMO of Nabarangpur as well as in Bhobanipatna, my lord, both of them are present before this honorable court by BC board, my lord. And they have filed also their affidavits, my lord.
Okay. Well. Just take us through those affidavits.
Lordship, may kindly take up, my lord, the Nabarangpur affidavit filed by the CDMO. Paragraph 3, my lord. It is amply submitted that the post of the doctors have been filled up by Odisha Public Service Commission. Recently, 38 numbers of doctors have been allotted to the Nabarangpur district by the Health and Family Welfare Department, Government of Odisha, on the recommendation of the OPSC. Copy of the allotment letter dated so-and-so is annexed herewith and marked as annexure so-and-so. Besides, for smooth management of the health institutions, 13 number of qualified interested candidates having MBBS qualification doctors have also been engaged on contractual basis by the district administration.
This is the first May affidavit, right?
My lord.
Which para are you reading?
This on 27/4/2023, this affidavit.
Oh, 27/4, 1 minute.
My lord.
We're reading the 1/5.
I'm sorry, ma'am. I'm sorry. Your lordship is reading the other.
Right. Yes. This is
Lordship, may kindly come to para 3, my lord.
para 3. Correct. All right.
Now, para 4, my lord, it is amply submitted that the vacant post of staff nurse, nursing officers shall be filled through the direct recruitment by the Odisha Subordinate Staff Selection Commission. Necessary proposals in the prescribed pro forma have been submitted to the directors of nursing, Bhubaneswar, by letter number so-and-so. Then, my lordship, may kindly come to...
This was more than a year ago.
My lord.
Almost a year ago.
My lord, what has happened actually, there is a case which is pending before this honorable court. Large number of matters which are also listed today at 3 o'clock, my lord, before Justice A.K. Mahapatra, wherein I am appearing for the National Health Mission, my lord. That was hard long back, my lord. And today it is to be mentioned, it has come. I hope and trust this matter will be disposed of so that government will be able to, my lord, take a decision also with regard to that.
About nurses, is it?
My lord, nurses, my lord.
Okay.
My lord,
Yes.
My lord, so far as Nabarangpur is concerned, my lord, my friend is reading, my lord. And my lord, on my lord direction on 9th February, my lord.
Right.
My directed to submit affidavit on 7 subject, my lord.
Right.
The first, my lord, filing of all the vacant post of doctors, my lord.
Right.
So far as filling of vacant of doctors, my lord.
Yes.
In para 3, which my friend was reading, my lord, earlier in Nabarangpur. This is a 27/4 affidavit, my lord.
Right.
It is saying, my lord, the post of doctors have been filled by the OPSC. Recently, 38 numbers of doctors have been allotted to Nabarangpur district by Health and Family Welfare Department, my lord. Besides, for smooth management of the health institution, 13 number of qualified interested candidates with having MBBS qualification doctors have been engaged on contractual basis.
Right.
It's not clear, my lord, how many vacancies are there. As per my knowledge, my lord, there is vacancies of doctors. And according to population, my lord, there is very less number of doctors are there appointed there, my lord. Till they are searching for doctors, my lord, for appointment. And so far as next para, my lord, for regarding nursing staff, my lord. It is saying, my lord, that it is humbly submitted that the vacant post of staff nursing officer shall be filled through direct recruitment by the Odisha Subordinate State Selection Service. Will be, my lord. Necessary proposal prescribed pro forma have been submitted on 26/6/2022, my lord. More than 1 year has been.
That is what just now put to him, sir. You're saying the same thing. I just now asked him about that.
Please.
You're again repeating that only. Let him place everything and then we'll hear you, sir. We'll hear you.
Then, my lord, also may kindly come to paragraph 6. It is humbly submitted that all the medical institutions of Nabarangpur district.
No, basically, even this pharmacist,
my lord,
you simply say you submitted a proposal.
My lord.
Now, what has happened in that proposal?
My lord, that I need to, my lord, take instruction what has happened, why these appointments are not being made. Because from the Odisha Subordinate Staff Selection Commission, my lord, we have to get the information that why it has not progressed so far, my lord.
See, that should have been already got, I say. Today's hearing is 16th of May. By now, you should have found out this affidavit has been with you for 2 weeks.
I had asked them, my lord,
Yes.
Lord, may I kindly see, my lord, the next is with regard to the medical equipments, my lord. It is humbly submitted that all the medical institutions of Nabarangpur district are functioning government buildings with adequate equipments, instruments, power supply, and water facilities, my lord. Then X-ray machines are available in the district headquarters hospital, Nabarangpur, subdivisional hospital at Umarkot, including all CSCs of the districts for providing health services to the needy patient, except in CSC Jhargaon, CSC Sanomoishuna, CSC Nandahandi, and CSC Paprahandi, which are situated nearby.
I think the only way to confirm all this to send again some team. Again, the DLSA will have to be sent. The same team should go now. That's the only way to do it, sir. Because this is again fully claiming that everything is now hunky-dory, which can't be. Overnight, it can't change. See, we expect the CDMO to be very frank, to say where he needs help, where he's unable to do things on his own. I told you even earlier, if you think court orders can accelerate things, you should say very frankly.
I have also explained.
But if this is the kind of affidavit that everything is fine, there's no problem anywhere, then what is the? Then we're treating it as adversarial. I keep telling you this is not adversarial. It is possible that attention of the secretary, health secretary, is not drawn to a particular difficulty. Like you have sent a proposal in June. We are now in May 23, 1 year almost. Nothing has happened.
My lord, I will assist you, this honorable court, my lord. I myself will also see to it, my lord, whether anything is to be done, my lord, and I'll talk to the CDMO.
This is like an affidavit of just claiming everything is fine. There's no problem anywhere.
CDMO Nabarangpur is present here.
Yes.
I would request
is there anything
CDMO.
He wants to add? Let him be. Yes, sir.
Sir.
Yes, sir.
CDMO Nabarangpur, sir.
Yes.
Yes.
Sir, are you a CDMO satisfied that everything is functioning very well, or you need some real assistance in improving your services?
My lord, things are well now, and whenever I am facing difficulty, I am bringing this matter to the knowledge of my authority, my lord.
Sir, you don't have enough nurses. Is that not a fact? You sent a proposal many months ago. Nothing has been heard.
My lord.
You sent a proposal for pharmacists in November. You have not heard anything. You're not able to tell the court whether you have enough pharmacists, enough nurses. And you're saying, no, whenever I write to the authorities, everything gets resolved.
Yes, my lord, proposals have been given.
Proposal sending is something, actually getting persons to work for you is another. Which is why you have to be frank, sir. You can't simply claim that everything is fine in Nabarangpur. Nurses are so essential for the medical public health system. You don't have nurses. You wrote a proposal in June 2022. We are in May 2023. And you're saying everything is fine.
Noted, lordship.
So we asked for your participation online only to frankly tell the court which are the areas in which you really need assistance, which are the areas where you're doing well. But you are now saying everything is fine all the time. You will compel us now. The same team will come and visit your services. They're going to come and say these claims are all not correct. In this CHC, we find there are no nurses, no doctors.
Your Lordship
This kind of
noted.
an affidavit, we need not have called for all these very detailed reports. Somebody has done a lot of homework. Somebody has visited each of your outlying stations, CHC and PHC. Somebody is telling you, sir, in this there are no drugs, no equipments, no nurses, no doctors. We expected you to tell us every PHC, every CHC, what's the position. We wanted you, every PHC, every CHC has a doctor in Nabarangpur. Are you able to say it on affidavit? If you say yes, we will record your statement here. This is the High Court. This is Chief Justice's bench.
Yes, my lord.
Every PHC, every CHC has doctors, nurses, pharmacists, drugs and equipment. We'll record your statement today. Are you prepared to say it on oath, sir?
In every session, PSC doctors are vacancy are there.
Mr. What is your name, sir? Doctor? What is your name, sir?
Kali Prasad Behera.
Dr. Behera, we will record your statement on before the High Court of Orissa that as CDMO of Nabarangpur, you're able to vouch for the fact that every PHC, every CHC has sanctioned, all the sanctioned posts of doctors, nurses, pharmacists are all filled up, they're all functioning. Shall we record it, sir?
No, my lord, actually, in all CSCs and PSCs, all the posts are not filled up, there are vacancies.
Why have you not told us that? What are we asking you for an affidavit from you then?
No time.
This is a waste. You're wasting the court's time, sir. Why are we setting it at 2 o'clock? We treat this matter very seriously. This is the whole public health system in Orissa. I'm sorry to say we're not serious about this then.
I had categorically asked my lord that which are the area wherein we are facing the difficulty.
And Dr. Behra, this is not one adversarial litigation. Do you understand what is adversarial litigation? Plaintiff will say X, defendant will say Y. And the judge has to decide whether X is correct or Y is correct. This is not that kind of a litigation, sir. All of us understand there is a problem. All of us work together to find a solution to the problem. If you're in denial, if people are going to the ground and telling you what the problem is, and as CDO, you're just saying, no, sir, everything is very fine. You don't even make the first step towards resolving the problem. You're the officer, sir, completely in charge of the public health services in Nabarangpur, correct?
Yes.
In fact, you should know more than what those teams found out for you. On a daily basis, you should be monitoring PHC, CHC, and DHH and all of that. Which is the next affidavit?
The next affidavit is filed by the Kalahandi, my lord. This not may kindly take up this affidavit. It was filed on
the Kalahandi pad,
my lord, 1/5/2023.
Right. He is present online.
My lord, the CDMO Dr. Girish Chandra Raut is present, my lord.
Yes. Yes, Dr. Raut.
Lords may kindly see the affidavits, my lord. Paragraph 3. It is humbly submitted that 9 numbers of doctors have been engaged on contractual basis from January 2023 to April 2023.
What happened after that?
And OPSC has allotted, my lord, 42 numbers of medical doctors.
Officers.
And they will join in the month of May 2023.
Okay, now let's stop here. Yes, Dr. Raut, are you there?
I'm present.
Yes, Dr. Raut. So tell us about this. 9 doctors were engaged from January to April. I hope they are continuing.
Sir, they are continuing.
Contractual means what, sir? You pay a lump sum every month.
Yes.
70,000 per month contract.
So how do you choose them, sir?
CDMO has the power. CDMO has the power to choose. They will apply to CDMO and.
You are only select. You are only CDMO, sir. On what basis did you select 9 doctors?
They will apply. Then we just consider vacancy.
No, I'm asking a simple question. How many of them are gynecologists?
No, only MBBS. Only one pediatric specialist has joined on contractual basis at Kesinga. Others are MBBS. Actually, we are having for 4 sanction strength 404 total including gynae all specialists, and in position there are 173 doctors. 31 posts are vacant. In the meantime,
the woman comes with, so if a woman comes with a complicated pregnancy, what will happen?
They are conducting the delivery in the CSC. In CSC, every CSC at least 1 or more doctors now. No CSC.
No. Are they trained in all these things, sir, to take care of cesarean complicated surgeries, complicated deliveries? Are they equipped?
They can do cesarean, but they are conducting the normal deliveries. In case of difficulties, they are referring to the nearest sub-division hospital. We are having one sub-division hospital, Dharmagad, and one area hospital, the CSC. They are specialists, gynae specialists. They are conducting the cesarean section there. Also, 3 to 4 the specialists at district headquarters hospital. They are conducting the cesarean section. As we have a LOP for medical college, there are around 4 more gynae specialists have joined in medical college. They are also conducting the cesarean sections. In peripheries,
the entire Kalahandi, how many specialists are there? I don't know. You're calling gynecologist specialist. We'll go by that.
Yes.
So you need a pediatrician will be a specialist.
Yes.
Gynecologist will be a specialist. Neurologist will be a specialist. Cardiologist will be a specialist. So in terms of specialization, how many specialists do you have in the whole of Kalahandi?
Of the specialist, total 11 is there. 13 posts are vacant. Of the specialist, census post 24. Then 13 now.
The specialized post is 24, he says, out of which they have filled up 13. 11 and 13 are vacant.
For kidney dialysis, you need nephrologists, correct?
Dialysis unit is going on district headquarters Kalahandi, that is Bhavan Patna. 7 machines are in position, they are functioning well.
For a minute, my lord, let me kindly come to my next paragraph. During the academic session 22-23, government has been pleased to give permission for admission of 100 MBBS students in Government Medical College and Hospital Kalahandi at Bhavanipatna after LOP given by the National Medical Commission. Till date, 68 number of faculty members of different specializations as well as super specialization have joined the Government Medical College. Construction of academic block, including staff quarters, hostels have already been completed, and a 650-bedded hospital is under construction at Government Medical College campus. Now, Government Medical College and Hospital is functioning at DHS Kalahandi. Accordingly, all the required infrastructure, development, etc. have been completed, and specialized services such as medicine, surgery, gynecology, orthopedics, skin, TB, chest, eye, ENT, psychiatry are also resumed at DHS Kalahandi. This will definitely helpful for the better health services to the poor patients of the district as well as adjacent district. Accordingly, in order to fill up the vacancy of specialists, government have made provisions to engage specialists in KBK districts out of corpus fund. In spite of 3 rounds of advertisement, only 1 specialist in pediatrics has joined at CHC Kesinga and continuing his job there. Further, 44 number of Ayush doctors under NHM, they are co-located, and RBSK is the Rashtriya Bal Swasthya Karyakram, my lord. was posted at the district level CDMO PHO Kalahandi by order number so and so, out of which 13 have already joined.
Ayush doctors means what?
My lord, under that National Health Mission, my lord.
No, these are not allopathics.
No, these are not allopathics.
Ayurvedic.
The Ayurvedic and homeopathic, my lord.
So they can't do any surgery.
They can't.
Same, sir. Nursing, you sent requisition on 15th December. What is your shortage of nurses, sir? Dr. Raut? How many nurses do you need? How many nurses do you need? How many nurses do you have? Actually, I expected both you and your colleague to tell us these things. How many doctors do you need? How many doctors do you have? How many nurses do you need? How many nurses do you have?
Nurses are we need for 52, now in position 369.
252.
Or 52.
452, and how much do you have, sir?
369. 369.
369.
Lab technicians, what's the position, sir?
Section state 55, now in position 54.
Also, may kindly come to para 5. That is humbly submitted that 10 number of laboratory technicians have been appointed and posted to different medical institutions of the district.
So the thing is, we don't know how many are vacant. Sir.
Yes, my lord.
That kind of an affidavit doesn't help at all.
I completely bow down, my lord. This
Only one vacancy.
Says one vacancy.
29 are there, position. 25 have been posted in the recent past months. So total now 54 in position. Our section is 55.
The thing is, we have only picked up 2 districts in all of Orissa, and look at the position on 2 districts. We don't know about the other districts.
On 24th September 21, my lord. I'm sorry, my lord.
No, that's true, sir. See, the point is this. They don't seem to appreciate that this is non-adversarial. We are not asking for some report card where they have to demonstrate they are the best district. The whole attitude is something else. See, they say all medical institutions, look at para 7, please read it.
Well,
all medical institutions, Kalahandi, are functioning with adequate equipment, instruments, power supply, water facilities. Why are we making claims like this? I am compelled now, the same teams will visit all these institutions now. We'll get a report in 2 months which demonstrates the incorrectness of the statement. What is the benefit in all this?
In ambulance services, my lord.
Dr. Raut, I think I'm sorry, I'm repeating what I told Dr. Behra. This is non-adversarial, sir. This is not like asking a report card where you're going to be given a medal or, given marks. We all know there is a problem. We all want to find how to reduce the problem.
In ambulance services, my lord, there is only 54 ambulance are in functional in Kalahandi district, my lord, for 18 lakhs population. My lord.
What they're also not realizing is because of the inadequacy of these services, people are forced to go to private healthcare. They're spending huge amounts for consultation fees, for testing in laboratories.
So may kindly see para 9.
Dr. Raut, obviously there is private medical practice going on. All your doctors serving in the public health system are also carrying on private practice, correct?
They are doing some private practice, no doubt. Because now the private practice is allowed.
Sir, every person coming into your hospitals is going to a private doctor. Every person who needs an X-ray test in your system will go to the private lab.
No, no, sir. Now the
So the problem, Dr. Raut, is this denial. The problem is the denial. If you actually went out into one Kesinga or some other place or anywhere, you will get to know the reality of the situation. Do you undertake any surprise visits, Dr. Raut? Have you undertaken any surprise visits to your CHC, PHC? Never. Never. Sir, you can never get to know the reality of a situation unless you get totally involved.
I joined 2 months, just 2 months back.
Sir, wherever you joined, sir, wherever you joined, it's not different in Orissa. We have simply, for a sample, picked up 2 districts. We don't know what the situation in other districts, but I can tell you with some reasonable certainty that it's not very different. And Orissa is not an exception. We are talking of an all India situation. But just because it is bad elsewhere, it doesn't have to be equally bad here. Why don't you pick up the challenge? Why don't you show that Orissa can do something that the other states cannot do? So both Dr. Behra and Dr. Raut, you must show that Kalahandi and Nabarangpur can, despite all these odds, perform far better than other districts in Orissa. You should see this as an opportunity. You are the head of the entire public health service in your districts.
In spite of sufficient manpower, we are trying to manage the situation. Actual problem is here in these districts because the districts is so much interior and many more areas have to reach areas. That's why actually persons are now staying in the headquarters sometimes. Still then we are trying to manage with the available staffs. Government also is trying. Now they have proposed to post around 42 allopathy doctors, but they have not joined. The process is going on. In short time, they will also join. In so much problem of the doctors, to some extent it will be solved. Actually, we are running on manpower in Kalahandi district. Till then, we are managing.
What you actually need, if you frankly tell us, we can issue directions. If you say, sir, I'm managing, I'm the best district in Orissa, I'm doing 100% well, I have no problem at all. If you have that attitude and say, sir, I don't need any help, I'm managing excellently well, all my people in Kalahandi are very delighted with the public health service, then we will accept that and we'll say, okay, let us send back the teams to find out how true it is.
No, sir, no.
If somebody reads both your affidavits, they will think the health services in Orissa are the best in these 2 districts.
Yes, sir. We are always asking for the manpower and infrastructure. Almost we have infrastructure in all CSCs, PSCs. Only the shortage of manpower is main problem for us.
My lord, may allow me, my lord, we will file a better affidavit, my lord.
Not better, more than all these affidavits, sir. Actually, even I'm beginning to wonder whether all this is serving purpose. I want these people to get down on the ground. Move from PHC to PHC, CHC to CHC. We both are unable to do it because we have to sit in a court. If I was a CDMO, I'll be out on the field.
Such kind of progressive and proactiveness, my lord, I have already spoken to them. I told them that this is what is required.
That once you come into a position of, directing, I mean, it's like a CEO. Your whole attitude must be different, sir. And one must be honest to oneself. You know what are your strengths, what are your weaknesses, where you're falling short, where you need help. If you do not even acknowledge that you need help, how will you ask for help? I'm going to get the additional chief secretary health to come in. She has to have a meeting with these two. Actually, the situation is serious. You see, the court has, which is the other affidavit? Sorry, some other affidavit is there?
These are the two affidavits your lordship pointed out.
Right,
The two districts, my lord.
All right. I just want to tell both of you, Dr. Bera and Dr. Rao, please don't misunderstand us saying that we are sounding unreasonable or we are not understanding of the situation. It is because we understand the situation on the ground that we are surprised at the kind of affidavits that you have filed. We expect you to be very frank in saying what you, where you are lacking in resources, in manpower, in facilities. If you frankly tell the court, then we can do something about it. If you simply claim everything is fine, there's nothing we can do about it. I've got some problem in my body. I come to you for advice. Suppose I don't tell you what is wrong with me. I come to the doctor and say, no, sir, I'm enjoying excellent health. You will say, then you don't need any treatment. All right. You see the affidavits of both the CDMOs of Nabarapur, bracket dated 26th April 2023, and Kalahandi, bracket dated 1st May 2023, have been perused by this court. First of this court has also heard the submissions of Mr. Sanjeev Joshi, who appears in person, and Mr. B.P. Tripathi, learned additional government advocate. Stop. The court finds that while both affidavits purport to address some of the issues highlighted in the court's order dated 9th February 2023, neither affidavit is able to be candid about the actual ground situation as regards the public health system in both these districts. So both affidavits claim that adequate medical facilities in terms of doctors, staff, equipments, and facilities are available in both districts. Whereas a careful reading of both affidavits would show that there is a serious problem as regards adequate number of doctors, nurses, pharmacists, and most importantly, specialists in both districts. Full stop. Through the interaction with both the CDMOs who appeared in virtual mode, it has become apparent that single quote specialists like gynecologists, cardiologists, pediatricians, ENT, eye specialists, etc., are not available in adequate number in either of the districts, semicolon, that doctors are being engaged on contractual basis for short terms, semicolon, that proposals for appointment of nurses, pharmacists, etc., are pending with the government for months on end with no response. Full stop. Paragraph, the court would have expected both the CDMOs to tell the court, to inform the court the actual position with regard to each of the PHCs and CHCs in the respective districts, apart from the DHHs, in respect of doctors, nurses, pharmacists, and so on. In other words, what is the sanction strength and what is the working strength in each of these posts, and what needs to be done to fill up the gap. Full stop. Paragraph, this court would like to emphasize that this kind of litigation is essentially single quotes non-adversarial, unquote, full stop. As explained by the Supreme Court, in the words of Justice Bhagwati, in the Agra Protective Home case. I'll give you the citation. The first leg of the exercise is to correctly identify the problem. The second is first is to acknowledge there is a problem. Second is to correctly identify the contours of the problem. And third is to work together to find a solution to the problem. Full stop. The problem-solving mode, or the problem-solving capacity or potential, problem-solving potential of that a PIL offers, is what is being explored in this kind of a litigation. Full stop. It is not always possible to find a perfect solution or a complete solution, but certainly an attempt has to be made. Full stop. The court would have expected the CDMOs to have physically visited each of the facilities to give us a very frank feedback. Full stop. Paragraph. Mr. Tripathi offers that both CDMOs will file better affidavits explaining the actual ground situation in both of these districts. Full stop. At the same time, the court would like the same teams that earlier visited both these medical facilities in both these districts to again undertake a fresh exercise of visiting these facilities, since there is almost a year's gap between when they last visited these facilities. Full stop. The court would prescribe the same terms for their visits and request the DLSAs, the secretaries of the DLSAs in both districts, to assemble the teams in the same manner. And having undertaken these visits between (15th of June and 30th of June, to file reports with video clips and photographs again in this court as a comparison with what they saw more than a year ago. Full stop. Their reports be placed before the court before the next date of hearing with advance copies to counsel for the state and to Mr. Sanjeev Joshi, who appears in person. (27th July). 27th July.
Pardon, Lordship.
You say the court would like the Additional Chief Secretary Health to examine this court's the affidavits filed so far in this affidavits and reports filed so far in this matter, and to have a meeting with both CDMOs of Kalahandi and Nabarangpur before they file the further affidavit, the respective further affidavits in the matter. Mr. Tripathi offers to communicate today's order as well as the previous order to the Additional Chief Secretary Health for this purpose. Full stop. The court also requests the Additional Chief Secretary Health, apart from the CDMOs of Nabarangpur and Kalahandi, to participate in virtual mode in the next hearing.
Deeply grateful, my lord.
All right.
Pardon, Lordship. Item number 50. Lordship, I am receiving the Bhinama at 12:30 p.m. and after receiving the Bhinama for respondent, my lord, when I present before Lordship, the Lordship disposed of this matter already. Lordship, I've received the Bhinama 12:30 p.m. my lord, from the respondent number 1 to 7, my lord. But thereafter, I am present before the Lordship's court. Lordship already disposed of that matter.
All right.
Kindly they listed this matter tomorrow, my lord.
It's over, sir. It's over. Orders have been passed. All right.